Rule 33, Demurrer to Evidence. Section 1, Demurrer to Evidence. After the plaintiff has completed the presentation of his or her evidence, the defendant may move for dismissal on the ground that upon the facts and the law, the plaintiff has shown no right to relief. If his or her motion is denied, he or she shall have the right to present evidence. If the motion is granted but on appeal, the order of dismissal is reversed, he or she shall be deemed to have waived the right to present evidence. Section 2. Action on demurrer to evidence. A demurrer to evidence shall be subject to the provisions of Rule 15. The order denying the demurrer to evidence shall not be subject of an appeal or petition for certiorari, prohibition, or mandamus before judgment. Rule 34, Judgment on the Pleadings. Section 1, Judgment on the Pleadings. When an answer fails to tender an issue or otherwise admits the material allegations of the adverse party's pleading, the court may, on motion of that party, direct judgment on such pleading. However, in actions for declaration of nullity or annulment of marriage or for legal separation, the material facts alleged in the complaint shall always be proved. Section 2. Action on motion for judgment on the pleadings. The court may, motu proprio or on motion, render judgment on the pleadings if it is apparent that the answer fails to tender an issue or otherwise admits the material allegations of the adverse party's pleadings. Otherwise, the motion shall be subject to the provisions of Rule 15 of these rules. Any action of the court on a motion for judgment on the pleadings shall not be subject of an appeal or petition for certiorari, prohibition, or mandamus. Rule 35, Summary Judgments. Section 1, Summary Judgment for Claimant. A party seeking to recover upon a claim, counterclaim, or cross-claim or to obtain a declaratory relief may at any time after the pleading in answer thereto has been served, move with supporting affidavits, depositions, or admissions for a summary judgment in his or her favor upon all or any part thereof. Section 2, Summary Judgment for Defending Party. A party against whom a claim, counterclaim, or cross-claim is asserted or a declaratory relief is sought may, at any time, move with supporting affidavits, depositions, or admissions for a summary judgment in his or her favor as to all or any part thereof. Section 3. Motion and proceedings thereon. The motion shall cite the supporting affidavits, depositions, or admission and the specific law relied upon. The adverse party may file a comment and serve opposing affidavits, depositions, or admissions within a non-extendable period of 5 calendar days from receipt of the motion. Unless the court orders the conduct of a hearing, judgment sought shall be rendered forthwith if the pleadings, supporting affidavits, depositions, and admissions on file show that, except as to the amount of damages, there is no genuine issue as to any material fact, and that the moving party is entitled to a judgment as a matter of law. Any action of the court on a motion for summary judgment shall not be subject of an appeal or petition for certiorari, prohibition, or mandamus. Section 4. Case not fully adjudicated on motion. If on motion under this rule, judgment is not rendered upon the whole case or for all the relief sought and trial is necessary, the court may, by examining the pleadings and the evidence before it and by interrogating counsel, ascertain what material facts exist without substantial controversy, including the extent to which the amount of damages or other relief is not in controversy, and direct such further proceedings in the action as are just. The facts so ascertained shall be deemed established, and the trial shall be conducted on the controverted facts accordingly. Section 5. Form of affidavits and supporting papers. Supporting and opposing affidavits shall be made on personal knowledge, shall set forth such facts as would be admissible in evidence, and shall show affirmatively that the affiant is competent to testify to the matters stated therein. Certified true copies of all papers or parts thereof referred to in the affidavit shall be attached thereto or served therewith. Section 6. Affidavits in bad faith. Should it appear to its satisfaction at any time that any of the affidavits presented pursuant to this rule are presented in bad faith or solely for the purpose of delay, the court shall forthwith order the offending party or counsel to pay to the other party the amount of the reasonable expenses which the filing of the affidavits cost him or her to incur, including attorney's fees. It may, after hearing, further adjudge the offending party or counsel guilty of contempt.